Good afternoon. We're Group 8. I am Lee Yin Vanessa.
I am Tam Hoi Lam Clarice.
I'm Learn Xin York Cindy.
I'm Liu Yicheng Chini.
I'm Choi Xin Tang Janice.
Today, we will be presenting our arguments on the second question, which is related to the hurdles of small investors when asserting their rights by relying on the Securities and Futures Ordinance and the Companies Winding Up and Miscellaneous Provisions Ordinance under circumstances where misleading statements or material omissions have occurred in the fundraising exercise by a company. We have divided our presentation into 4 parts, which are the introduction, reliance, retail investors in secondary markets being disadvantaged, and lastly, the conclusion. I will first give a brief introduction about our topic. Under Hong Kong's jurisdiction, a comprehensive regulatory framework was established to govern the operation and misconduct of companies for the sake of protecting the interests of investors and ensuring the credibility of the financial market. For instance, legislations including Cap 571 SFO and the Cap 32 CWU-MPO are enacted, with specific provisions regarding misleading statements or material omissions of the company in a fundraising exercise. Yet, owing to the high cost of the expenses associated with litigation from the perspective of retail investors, there has been skepticism suggesting that the rights conferred under these regulatory regimes are perceived as illusory as they face challenges in recovering the losses suffered. Therefore, it is necessary to conduct further investigation on the effectiveness and practicability of the selected provisions under the 2 ordinances, as aforementioned. Hence, this presentation attempts to critically analyze the obstacles encountered by small investors in asserting their rights under 2 aspects, namely reliance and retail investors in secondary markets being disadvantaged.
Now we will talk about the first aspect regarding reliance. First of all, retail investors who are constrained monetarily may encounter obstacles when endeavoring to establish the requirement of reliance to claim their losses under certain provisions of the SFO. Practically speaking, investors may potentially be entitled to civil remedies by demonstrating reliance in circumstances where companies circulate false or misleading information during fundraising activities statutorily. Sections 281 and 305 of the SFO create legal liabilities to compensate investors for any financial losses incurred due to market misconduct. For instance, the violation of Sections 277 and 298 of the SFO. Also, it is specifically stipulated in Section 391 of the SFO that individuals manifesting reliance on untrue or deceptive public communication concerning securities or futures contracts should be eligible for compensation. However, the practical application mentioned above may be subject to hindrance in real-life settings. In Securities and Futures Commission and Quinsing Paper Holdings Company Limited No. 2, the company has materially inaccurate or deceptive statements in respect of the financial performance published in its initial public offering IPO prospectus. Untrue information was also identified in the following annual reports and results announcements. The court held that the company's dissemination of false or misleading information constituted an infringement of the provisions of Sections 277 and 298 of the SFO, thus violating respective provisions with the objective laid down under Section 213 of the SFO. Speculations regarding the practicability of exercising the aforementioned regulatory regimes under the SFO by retail investors are discussed in court.
There are several issues identified in the procedural operations. The court determined that the framework was seemingly too idealistic and was unable to cater to the needs of the retail investors living in a more complicated landscape in reality. Nonetheless, in practical terms, the framework is either not entirely determinable or can only be obtained through a time-consuming procedure, which may not be easily comprehended by retail investors. Adhering to the practice of examining particular circumstances surrounding each investor and establishing the presence of reliance could undermine the effectiveness of the regulatory mechanism and is against the original intent of the legislature. Moreover, there are significant difficulties in verifying whether retail investors are merely influenced by or rely on the misstatements in the documents released to the public by the company. With the involvement of a substantial number of retail investors during fundraising activities in the claim, A considerable amount of time and effort will be spent by the courts and relevant authorities in collecting and examining the evidence. This will inevitably result in a vastly complex, lengthy, and costly process. The financial losses that retail investors might be able to recover are generally not proportional to the high litigation costs stemming from the legal proceedings. Therefore, it is not unexpected that no efforts have been undertaken to examine the requirements of reliance and inducement with respect to each individual investor in this particular situation. This common phenomenon can be observed in other cases involving misleading content and information found in companies' official documents. Rather than individual actions taken by the aggrieved retail investors, the SFC often commence proceedings against the companies involved in these allegations. In SFC versus Hontex International Holdings Company Limited and others Hontex, the court held that there is a contravention of Section 298 of the SFO and that the company negligently incorporated inaccurate and deceptive material in its prospectus. Further, in China Metal Recycling Holdings Limited No. 3, there was a violation of the same section as the company provided fabricated figures of company revenue contained in the prospectus. Some contend that the SFC is more inclined to utilize Section 213 of the SFO to pursue remedies in protecting the interests of retail investors. However, it is noteworthy that the SFC has discretion on whether measures shall be taken to secure remedies for serving the interests of investors and address the issue of retail investors disinclined from pursuing legal actions individually owing to cost issues despite their comparatively minor losses. Retail investors are therefore placed in a rather passive position. Where the SFC has not exercised its powers under Section 213, retail investors still have no way to get around the lengthy court procedures of establishing reliance.
Next, it is observed that the current statutory provisions have put retail investors in the secondary market in a disadvantaged position. It is common to see retail investors active in secondary markets. Unfortunately, the traditional common law position does not allow investors who allegedly buy shares on secondary markets in reliance on the company's prospectus to sue for misrepresentation. In Peek and Gurney, the court stated that a prospectus serves as an invitation to potential or regional shareholders. Thus, the passing of shares to them shall mark the completion of the prospectus duty. It was held that direct communication between parties who are answerable for the prospectus and the party who claims to be deceived is required for a successful claim of misrepresentation. In other words, only allottees of IPO are entitled to sue. CWUMPO Section 40 follows the stance of common law, offering protection solely to buyers of IPO. Section 40 is on civil liability incurred for misstatements in the prospectus. It is stipulated that subscribers who suffer loss due to false statements in the prospectus shall be compensated. However, only those who purchase shares or debentures with reference to the prospectus are seen as subscribers, indicating that Section 40 is not applicable to retail purchases in secondary markets, even if they sustain losses for relying on untrue content in the prospectus. Some may argue that buyers in secondary markets can turn to Section 108 of the SFO to recover their losses. Section 108 provides that investors who acquire shares by reason of any misrepresentation can seek damages from their representor. Yet, there have been debates concerning the coverage of this section. The statute requires plaintiffs to be induced by the misrepresentation to claim compensation. It is uncertain whether the defendants intend to have the plaintiffs rely on the representation is necessary. If it is compulsory, the rights of retail investors will be at risk, especially where the misrepresentation in the case is found in a prospectus, which is generally issued for the mere purpose of IPO. Defendants may then argue that they did not intend potential purchasers in secondary markets to rely on the prospectus. In this instance, retail investors will likely lose in their lawsuits.
Even if the above intention is not essential, the threshold nonetheless appears high for non-professional buyers to obtain money damage under Section 108. As aforementioned, one must be induced by the misrepresentation and into entering into a contract to subscribe for shares. The burden therefore lies on the claimants to prove that the losses that he suffered was caused by the misrepresentation. In Wong Hai Hong and Others and JP Morgan Securities Asia Pacific Limited. The court ruled that the claimant's cause of action accrued when they acquired the shares relying on the negligent statements made by the respondents. Direct reliance was also held necessary to satisfy the causation in Ingots Capital Investment and Macquarie Equity Capital Markets. Lord Halsbury commented in Macleay and Tate that a prospectus served to induce investors to take shares as a whole. Hence, subscribers can hardly analyze their own mental sensations so minutely as to be able to explain that their investments were made due to a specific representation. This can be particularly difficult for retail investors who have only limited or even no knowledge or experience in investment. They will likely lose their case for failing to prove a causal link. Not only can they not cover losses suffered, but also incur extra costs for engaging in litigation. To conclude, a considerable amount of time and efforts are needed to verify whether retail investors are merely influenced by and rely on the company's misstatement under relevance provision of the SFO. Even though the SFC may commence proceedings under Section 213 of SFO against companies involved in these allegations to protect the interests of the retail investors, in the latter nevertheless confined to a passive role. Meanwhile, Section 40 of the CWUMPO protects only IPO buyers' rights. Its alternative, Section 108 of the SFO, has an uncertain coverage and adopts a high threshold of causation. For the above, we believe that the rights of the retail investors are illusory, as their losses do not typically justify the cost of engaging in litigation. This is the end of our presentation. Thank you.